Okay, so as we transition into the first segment, we will explore challenges individuals face with a criminal history, um, especially when they're seeking stable, affordable housing. Today, we have two esteemed speakers who will provide legal and policy perspective on this issue. So first, we welcome Jacob Davis, partner and managing attorney at Knowles Davis. Jacob specializes in commercial litigation, real estate, and fair housing law. He chairs the firm's litigation and fair housing practice groups, has led over 200 housing discrimination investigations, and serves as a trusted advisor on civil rights issues. Jacob earned his law degree from the University of Dayton School of Law, and he will provide valuable insight um, into how a criminal record may impact housing access, fair housing protections for individuals with a criminal history.
Thank you so much, Miranda, and thank you for John and the Miami Valley Fair Housing Center and the City of Dayton Human Relations Council for putting together this event. I think the Fair Housing Collaborative is now going on, 4 years old, and to see this many attendees and this many organizations come together and continue this work is really great and a testament to all the great work that's being done in the community. Really, I'm tasked today with talking about the legal aspects of criminal history and its impact on housing. I do have a PowerPoint, and I think it is going to be shared with the group. I will share my screen. I'd be happy to answer questions during the Q&A session. So if you have any questions, just make a note of that, and we'll be happy to stick around and talk to anyone who has questions further after the event as well. I will go ahead and get started. John, as long as everyone can see my slides, I'll continue. If I don't hear anything, I'll just keep going.
They're looking good.
As Miranda mentioned, my name is Jacob Davis. I'm an attorney here in Dayton. A large part of my practice is based on real estate and fair housing law, really litigating cases at the federal and state level, and also before administrative agencies. I really want to talk today about the Fair Housing Act, protections that people with criminal history have, and then some best practices for housing providers whenever they are evaluating applicants with criminal records. That way, kind of everyone who's on this call today, I understand you might be representing organizations or applicants, individuals with criminal records can walk away with something from this presentation. I do note and put this disclaimer out there that the current administration has not issued much guidance on criminal records policies in the first couple of weeks. Therefore, my presentation today is really based on the guidance that is now in place. As we move forward, it'll be critically important that everyone in this space continue to monitor some of the new guidance that is implemented with this new administration. Really, I want to start my presentation. I'm going to go fast because I know John will cut people off if you go over time. So I'm going to speed through this as quickly as possible and also make sure that all of you get the slides. But we really want to start with the Fair Housing Act and what it is. The Fair Housing Act is a federal statute that Congress enacted back in 1968 that prohibits discrimination in housing, really both in transactions and services. So what we're talking about today is relevant with the fair housing lens because criminal record screening policies can create barriers to both housing access and mobility. There are a couple of ways the Fair Housing Act is enforced. It's important to note there's a federal agency, HUD, that enforces the Federal Fair Housing Act for the federal government. The Ohio Civil Rights Commission enforces the Fair Housing Act for the state of Ohio, and then the City of Dayton Human Relations Council enforces the Fair Housing Act here at a local level. For a big part of my conversation, I really want to talk much of what I'm going to refer to today. I want you to be thinking about the purpose of the Fair Housing Act, which was to ensure that everyone had equal opportunity to buy and rent a home, and really to increase mobility and access to housing. And what I mean by that is you should be able to live where you want to live so long as you are otherwise qualified. And the Fair Housing Act creates some protections to ensure that that happens. The Fair Housing Act does that through protected classes. You'll hear this, sometimes referenced with statutory law and then also with the Constitution. The Constitution has some protections, but then Congress is able to enact laws, and that's what they did with the Fair Housing Act. And there's 7 federal protected classes under the Federal Fair Housing Act. The ones that are going to be most relevant to our discussion today are race, color, national origin, and disability. Housing policies that disproportionately impact these groups may violate the Fair Housing Act, and I'll give some examples of that in a later slide. I do want to note that, we're talking about the Federal Fair Housing Act, but anyone that's working in this space, it's also important that you check your local ordinances because state and local governments may choose to have more protected classes, more protections for tenants, prospective tenants, and people who are trying to buy a home, who are trying to refinance and maybe are getting an appraisal. A state or local government can give you more protections and more protected classes, but never less than the Federal Fair Housing Act. So when we talk about protected classes on the federal level, criminal history is not necessarily a protected class, but we'll go into why there are protections for people with criminal histories on a later slide. But if you're in a state or a municipality, it's possible that that city or township or whatever it is may have a protected class for someone with a criminal record. For example, the city of Seattle has a fair chance ordinance, which makes criminal history a protected class in the city of Seattle. I think the city of Dayton, just going back on that last slide, I think we're up to 12 or 13 protected classes now. So just to give you an idea that this, what I'm talking about with protected classes is a thing. The most I've seen in any city is probably 27. And then obviously the least amount is the federal level of 7. Really want to move into disparities in the criminal justice system because that sets up the rest of our conversation on how criminal history screening can impact housing access and mobility. We know from research, studies, and statistics that there are racial disparities in both arrest and incarceration rates. And this is at the federal level, the state level, and oftentimes at the local level as well. At the national level, African Americans make up approximately 13% of the population. And this number next to it that I have in the slide is fluid at any given time. But although African Americans make up only 13% of the population, most recent statistics say they make up about 28% of the incarcerated population. We also know that African Americans are arrested at a rate of approximately 5 times their white counterparts. And I want to note on this slide that Hispanic arrest and incarceration rates are similar to African American arrest and incarceration rates. So we know from all of the research, all of the studies, all of the statistics that are put out that Black and Hispanic individuals are disproportionately affected when it comes to arrest and incarceration. We also know that individuals with disabilities also experience higher rates of incarceration for a variety of reasons, and we'll talk about that later, time permitting. Moving into how criminal record screening policies can impact housing access and mobility. One of the big ones that I see in my law practice are policies that housing providers have, which really are blanket bans on applicants with criminal records. And what I mean by that is there's just a policy that says, if you've been arrested or, you have any felony on your record at any point in time whatsoever, then you cannot rent from us. A blanket ban or a policy that is in effect a blanket ban for applicants who have been arrested or incarcerated by its very nature makes housing less accessible for Black, Hispanic, and disabled applicants, just based on the statistics we looked at on the previous slide. And we'll talk about why that's important once we get into the standards for establishing this type of claim and the potential liability that would exist if you have a blanket ban and that type of policy in renting out units, apartments, houses to applicants. Another one that is kind of cropping up in practice that I'm seeing more and more of is the use of third-party screening companies with biased algorithms. And the way this plays out, this really applies to both large housing providers and small housing providers. We're seeing more and more owners of properties or companies who are outsourcing, the application part of renting out a unit. And when they do that, oftentimes they're not asking that third-party screening company, about any of their policies with respect to criminal history. They're not asking about, what type of an appeals process a prospective applicant would have if something was found and there's an automatic denial. Just because a third-party company finds an arrest record for John Smith, it doesn't necessarily mean that that is the John Smith. So how can we correct that false information, which would lead to a denial under one of these potentially discriminatory policies? So what I would say here is we're seeing this more and more often when if you're a housing provider and you're using a screening company or a third party, you want to make sure you know what that third party screening company is, what they are doing, what their policies are with respect to criminal histories, and allowing potential applicants to correct any deficiencies that that screening company might find. Another one we're seeing and have seen over the years is eviction of tenants based on criminal records unrelated to a tenancy. And really what I mean by that is, just to give you a hypothetical, you're out driving one day, you're going 70 in a 35 because you're in a hurry, and you get arrested for that for whatever reason. The officer's having a bad day and decides not to cite you, just arrest you. If a housing provider has a policy that you cannot rent from them if you've ever been arrested or you've been arrested in the last 5 years, and you're arrested for a speeding violation, that person might, under your policy, technically not be able to rent from you. But we know that that's a speeding violation, and that is entirely unrelated to your tenancy. So a better practice is to conduct an individualized assessment of that applicant and make a determination as to whether or not they're qualified to rent. Just because someone's arrested does not necessarily mean they're not going to be a great tenant. Doesn't mean they don't have a dependable income or they're not going to pay their rent on time. And then this last bullet point is probably the one that I see most often just in my individual practice. And, I understand that can vary, attorney to attorney, municipality to municipality. But we often see policies that deter individuals from even applying. And maybe that's not even the policy of the housing provider necessarily, but a leasing agent or a person, an agent who is handling the transaction for the owner of the property, makes some type of statement. And it's just, to give you this example, per our policy, you cannot have any felonies on your record. Well, that is in effect a blanket ban. And we do know that generally will have the effect of a person not applying for the unit because they don't think they're going to qualify based on a potential felony that maybe they had 20 years ago, where they've rented for 18 years or 19 years and they've done everything right to go through the rehabilitation process. But because you have a leasing agent that said that was your policy, now you're in front of administrative agency or you're in court having to fight about this because your policy was communicated and was in effect discriminatory. So all of these can impact housing access and mobility. And we'll talk about some best practices on a future slide to avoid some of these actions that can lead to potential liability. 2016 HUD guidance. I want to talk about this because this is kind of the guidance that we are doing this presentation off of. In 2016, the Department of Justice and HUD issued some guidance on this topic, and in effect, it said housing providers must consider whether policies have a discriminatory intent or effect. And there are three theories of liability under this type of claim. There's an intentional discrimination claim, which is otherwise known as disparate treatment, a disparate impact claim, which is really a neutral policy that disproportionately harms a protected group. And there's a failure to make reasonable accommodation claims for individuals with disabilities. Disparate treatment claims, which are intentional discrimination. What we're really talking about there is you can even think of it can play out a number of ways, but it could just be a housing provider saying, we're not going to rent to any applicants. We don't do that. We don't rent to any applicants that are black or who have ever been convicted of a criminal record. If you do that, you have an intentional discrimination claim. We also have a disparate impact claim where we're looking at statistics. Talking about investigations, and I know I'm probably running close to time, but I will run through this pretty quickly. Government investigations, HUD, OCRC, and the city of Dayton can investigate when they receive a complaint of discrimination, or they can bring their own complaints. So this usually, the second point, they can bring their own complaint, usually pops up when agencies or organizations or individuals see something in the community and they report it to that government agency. And there's enough there that says, okay, we might want to get to the bottom of this. And there are so many people I recognize on this call who do represent tenants and work with people who have criminal histories. If you see something that seems to be not right and seems to potentially be discriminatory, it's important to report that because it creates a documentary record, and then fair housing investigators can review those actions, policies, and practices of that housing provider to see if there is any potential liability or if something needs to be done to make the situation right. I mentioned this earlier, discriminatory intent is assessed through evidence of differential treatment. So if you're treating white tenants differently than black tenants or disabled tenants differently than tenants without a disability, then you have a potential discriminatory intent claim. And with disparate impact, we're really looking at statistical evidence. We're looking both at the federal, state, and local levels to make determinations as to whether or not this protected class will suffer some type of differential treatment because of the neutral policy that is otherwise discriminatory just based on statistical evidence and the disparate effect that it creates. Defenses, housing providers will often argue that criminal screening policies are for the safety and well-being of residents. I just want to note it's very important. Policies must be supported by reliable evidence. They cannot be supported by stereotypes. I have litigated cases like that before, and certainly the law is pretty clear on this, that if you're a defendant in this type of case, that you absolutely have to have reliable evidence and you can't rely on some stereotype. Just a reminder, arbitrary bans on individuals with convictions likely violate the Fair Housing Act under current guidance. Certainly stay away from, if you're a housing provider, stay away from anything that is not an individualized assessment of each and every applicant that comes through the door. You should have those conversations even if you're using a third party to screen applicants, just to make sure you know what their policies are, find out what their appeals process is for a tenant to appeal the denial and the decision that they made. Reasonable accommodations. I just want to touch base on the fourth bullet point here briefly. The first and the fourth, individuals with disabilities may request reasonable accommodations with regards to a disability-related need and past criminal conduct. With disability, sometimes people think it's got to be some type of physical disability, and they think wheelchair, but the term disability under the Fair Housing Act is more encompassing than that. So going to the fourth bullet point, group home operators have a right to request reasonable accommodations to operate. This is kind of cropping up in cities right now with like spacing requirements and moratoriums on people opening group homes. Those group home operators do have the right to request a reasonable accommodation under the Fair Housing Act, and then the municipality has to determine whether it's reasonable or necessary for that accommodation to be granted. Best practices, avoid blanket bans on applicants with criminal records. I can't get that point across enough. I've certainly had cases where I've litigated against housing providers who have had blanket bans, and they usually always say, "Well, I don't really have a blanket ban." But once we get into the documentation, everyone sees that it is a blanket ban. So that's kind of the most important point. Avoid a blanket ban on applicants with criminal records. Conduct individualized assessments of every applicant. Provide applicants an opportunity to correct inaccurate reporting, and then delay criminal background checks until financial qualifications are already verified. Criminal history is not currently a federally protected class, but your actions and policies may still be discriminatory under the Fair Housing Act, and more particularly race, national origin, and disability protections. And then lastly, and most importantly, housing providers need to balance safety concerns with their fair housing obligations, or they could subject themselves to a potential lawsuit. That is it, and I will stick around for questions.